All right, good morning, everyone. Welcome. My name is Stanojcic. I'm an attorney at Doré Rothberg McKay law firm here in Houston, Texas. I head up the firm's oilfield services contracts practice, much of which is focused on MSAs, which is what we'll be discussing today. I just wanted to clarify that I'm using my partner's Zoom account to do this webinar. So that's why his name, Zachary McKay, appears below the video feed. Just wanted to point that out. So the impetus behind this webinar is the unprecedented situation that our industry is encountering currently. And, you know, as the graphs here clearly illustrate, this is, you know, something that our industry probably hasn't faced before, even though with all the ups and downs we've had in the past. So we wanted to discuss how this current situation will affect master service agreement negotiations, particularly going forward here in the near future. And we also wanted to touch on force majeure clauses, about which there's been a lot of talk about lately in light of recent events. I have my email posted up here. You can feel free to reach out to me with any questions or comments. I would appreciate that. And so let's get into it. So the two topics we're going to touch on today will be how the current global market conditions affect the negotiation execution of new MSAs going forward, you know, based on our firm's perspective. And then we'll also touch on some guidance for reviewing and interpreting the force majeure provisions in your current MSAs that you have in force with customers. So our team's basis for Outlook, we review MSAs and other oilfield services contracts, NDAs, purchase and sale agreements for equipment, things like that, rental agreements, for an array of clients, both big and small, from smaller local operations to some of the major oilfield services companies. And that portfolio of goods and services that our vast array of clients has is everything from produced water hauling to production equipment manufacturing and installation to the full service portfolios, including rig-based services. So our firm's outlook for the near futures and what's going on currently, what we're seeing is not good, in the sense that the number of MSA review requests has fallen off sharply as of March, due to this confluence of the pandemic, economic recession, and the issues with OPEC and the oil price war. The good thing is we think the oil and gas industry has a willingness and a discipline to adapt to this new situation as it always has, and that there's going to be a self-constraining to try and reduce some production and cut excess spending and cut, you know, this crazy gangbusters kind of attitude we had for a little while, and to bring the domestic production to a more realistic and level. So, and that, I think, as all of us know, it's based on the logic that we all know that at the local gas station, a gallon of gas should be more expensive than a gallon of water. And unfortunately, that might not be the case currently in some parts of the country. So our team's projection for 2020 is that the MSA reviews are going to pick up through the end of the third quarter, through early fourth quarter. But we think the focus of this is going to be on renegotiating soon to expire, already expired MSAs, instead of negotiating first-time contracts. And then we think that, you know, with everything that has occurred in the recent past, these negotiations might take several different forms. They're likely going to be operators pushing for the service companies to provide very broad warranties with no warranty liability caps, to carve out breach of contract and breach of warranty claims from the operator side of the knock-for-knock indemnities, and for service providers to take on more liability than usual for loss of or damage to their downhole tools. So some provisions that operators will likely seek to negotiate. Traditionally, the knock-for-knock indemnities, as most people know them, and probably how you're familiar with them, have either been regardless of fault, would include gross negligence, or at most included an exception for the indemnities' own gross negligence or willful misconduct. That's what most of us are used to seeing in MSAs. But operators now may attempt to expand that carve out to simple negligence, breaches of contract, or breaches of warranties. And we're already seeing a push in some MSAs from some operators on this point. So this is a thing that we're going to need to watch out, and that you should watch out in your MSA review and negotiation process in the near future. And we have an example of that kind of carve out highlighted in red in this sample clause. So another provision, another area that operators are probably going to push on is in the downhole equipment, downhole tools loss risk allocation. And typically we try to narrow this carve out to the operator's responsibility for the loss or damage to downhole tools solely to contractors' gross negligence or willful misconduct. And so, and that's because logically much of what occurs downhole that could lead to the loss of the equipment is ultimately beyond the control of the contractor. The operator is in charge, ultimate charge of the well site. So this broad kind of carve out, we think, provides too big of an out to an operator. And we think it's more likely that if something does happen and downhole tools are lost or damaged and a dispute arises, that there's going to be a greater impetus for the operator to take a shot at litigating the matter instead of just, saying, well, okay, well, it says that we're responsible for it. Let's just pay for this tool and move on. So an example of that is highlighted in red here. We want to try and narrow their exception to their responsibility as much as possible. This is another example of an area in the downhole tools and downhole equipment loss provision that operators may try to push on. And this is with respect to the depreciation schedule. The typical cap that we've usually seen, if it is specified at all, is anywhere between 30 to 50%. Operators now, and we've already encountered it on several occasions, may request larger caps or no caps, taking into consideration the current market conditions. And an example of that language would be, for example, here with this red highlight where it says the contractor's replacement cost of such downhole equipment less actual depreciation. Well, there's no cap specified, so the actual depreciation from their perspective could be almost anything, up to 100%, although that's, not likely. So we typically want this language to state something along the lines of contractors' replacement costs for such downhole equipment, less reasonable depreciation, which shall in no event exceed 30%. So that's something that most of our clients would be comfortable accepting. Another big area and another very important area for service providers, one that there's been a lot of litigation about, unfortunately, from the operator's side, both substantiated and unsubstantiated, has been with respect to the loss of or damage to wellbore and or underground property. And so for us, we think it's going to be very important to remain firm on this very specific provision in most MSAs. The operators are going to want to push back and shift some liability for anything that goes wrong downhole and potentially leads to their loss of use of the well, whether it's permanent or temporary. And so an example of how they're trying to expand the scope of this exception to their responsibility to indemnify a service provider for what happens to their wellbore and the underground property is highlighted here in red. And that isn't the traditional or the most often accepted carve out or exception, which is that, okay, in instances where the service provider is grossly negligent or engages in willful misconduct, and that leads to loss of the wellbore or the underground property, then the operator will not be responsible for that. But in this case, they're expanding it just to simple negligence, fault, and or willful misconduct of the contractor group, which we believe is too broad and inappropriate of an exception. And we would want to limit this back down to what has, traditionally been the case in most MSAs between most parties, which is we'll agree to the exception, but it should be for gross negligence or willful misconduct only. So another area also will be the pollution indemnities. We want to, same thing, if we agree to any kind of carve out from the operator's responsibility to indemnify us, it should be only for our gross negligence or willful misconduct. Generally, traditionally, the contractor takes responsibility for above ground pollution originating from its property, and the operator takes responsibility for all their pollution, including below ground, regardless of cost. So if we do have to grant an exception, we want to try and push for only gross negligence, willful misconduct. And we've seen some MSAs already where they're trying to slip in just simple negligence or fault of contractor as an exception to their responsibility to indemnify the service provider. So now let's move into that we've heard some examples of areas that are likely going to be renegotiated and where operators are going to push on. Let's move into the discussion of force majeure. This has been talked about quite a lot recently. A lot of people are asking, clients are asking, well, we might not be able to do this with government restrictions in place, or their vendors or suppliers are being restricted even though they are not, or just concern for their employees' safety. And so people are asking now, turning to force majeure and asking, okay, well, how could we obtain some relief contractually, or are we entitled to it in case we need it? So the two questions that most people immediately have is, well, aren't force majeure clauses just boilerplate? No, they're not. They could, in rare situations like this, be very important. And the second question that people ask is, well, don't they just relieve me on my contractual obligations? I mean, in a crazy situation like this is unprecedented, right? I should have some relief under the force majeure clause. Isn't that what it's intended? And the answer to that is maybe. It depends. And so we'll look at why that is. So what is force majeure? The term force majeure simply describes a legal doctrine that excuses one party's performance under a contract when a certain event or events occur which prevent that performance or make it overly burdensome or unreasonably difficult, depending on the standard. And we'll get into that as well. So this is a typical example of a force majeure clause, and we'll use this sample clause as our reference as we move through some of the analysis. So force majeure issues. When you go to analyze the force majeure clause in your contract, you need to ask yourself three main questions, three central issues that need to be resolved before you can get a clear analysis of whether you have relief under the force majeure clause or not. So the first question is, does the force majeure clause apply to the facts of my company's situation? So the facts that are rising to your difficulty in performing, or possibly could give rise to the difficulty to perform. The second clause is, if the clause applies, is my performance excused? So there's different standards, as I mentioned. Sometimes it has to be prevented, sometimes it has to be overly burdensome, and we'll get into that. And the third question you have to ask yourself is, if my performance is excused, how do I invoke the force majeure? So for the purposes of presentation, we'll assume that our force majeure clauses, the sample clause that we looked at previously, will be governed by Texas law. So how does the force majeure clause apply to my situation? So under Texas law, there is no boilerplate language that will serve as a catch-all. So there's no standard language you could include in a contract, in an MSA, that's going to encompass every single situation that could give rise to a difficulty or impossibility of performance. Texas courts, when they analyze these contracts, when they analyze these clauses, they're going to examine the contract's language specifically to determine the scope and application. First, they're going to look to the events specifically enumerated in the force majeure clause. So that'll be things like fires, floods, acts of God, hurricanes, tornadoes, governmental orders, insurrections, all the things that you've probably seen before to one extent or another in most force majeure clauses. So examining further the question, does the force majeure clause apply to my situation? So in the context of the coronavirus pandemic, the applicable language, if you have it in your clause, might be pandemic, pathogen, outbreak of disease. That's going to be a pretty concrete argument that the current situation applies, undoubtedly. Unfortunately, we haven't seen so far many of these clauses. It's likely that we're going to start seeing them from here on out, but so far in most oilfield services MSAs, you don't see this kind of language in the force majeure clause. Potentially applicable language would be act of God or governmental or regulatory orders or acts. So, and I think to keep in mind is, as a general rule when evaluating your specific language, is that more specific the language is, the more likely that a court will find the force majeure clause to apply. So the thing to draw from this is, unless your force majeure clause mentions pandemic, coronavirus, or something like that very specifically, your next best bet will be to rely on act of God or acts of government or something along those lines. So generally in Texas courts have found that an act of God, as that term is often used in force majeure clauses, refers to natural forces, events, or costs. So things like tornadoes, hurricanes, severe storms, floods, things of that nature. It generally excludes, and it generally means events without human intervention, such as hurricanes and floods and things like that, natural storms, as I mentioned. So it would have to preclude something where there would be human intervention. Consequently, it's not clear whether the current pandemic would qualify as an act of God. As I said, there's a good argument to be made if you don't have anything more specific to argue in terms of language in your force majeure clause. But there's also some counter arguments, like that the government intervention in response to the coronavirus pandemic is actually the factor which renders the performance impossible or difficult. And therefore, under Texas case law, it's not an act of God. So that might be a counter argument you would see from the other side if you ever had to litigate this. In addition to specifically listed events, a lot of force majeure clauses will include what attorneys believe, the drafting attorney believes, is catch-all language, although we said that that doesn't really exist under current Texas law. And this catch-all language is often thought, or is hoped that it will include all other unspecified events. So we can see the example from our sample force majeure clause on slide 12. Any other similar causes that are not reasonably within the control of the party so affected. So that would be an example of catch-all language. Unfortunately, what often happens when these force majeure clauses have been litigated is that the courts have found that that kind of language raises contract interpretation issues. And the way that courts have dealt with them is through applying a doctrine called justum generis. And so basically what that doctrine says is if the catch-all language comes after the specific enumerated list of events, like it does in our example, then the court will apply that doctrine, and it will mean that the catch-all cannot extend to events that are significantly different than the enumerated events. So the situation, if you had a force majeure clause that for some reason only described natural occurrences like storms, hurricanes, floods, whatever, and then you had a catch-all language similar to the one in the slide here at the end of it, a court would likely find that a pandemic or coronavirus would not be included under that catch-all language, that the catch-all language would only intend to include other types of natural occurrences that were not specifically enumerated. And so that's a thing to watch out for. And if you have an opportunity to renegotiate that, and if that language is in a force majeure provision, try and see if you can just move the language around to include it at the beginning of any list, including but not limited to, or something along those lines. Additionally, in Texas, the catch-all provisions can only apply to events that are unforeseeable. So this may not be the case depending on your specific language in the contract. So the second analysis is, well, if the clause applies, is my performance excused? And this, you will have to refer to the specific language of your force majeure clause. So the standard by which your inability to perform is measured will likely be described in the provision itself. So the first part of that is what standard applies to your inability to perform. If your specific language in the force majeure clause says it has to make it impossible or illegal for you to perform, then that's the standard. If you can still somehow perform, or if it's not illegal but extremely burdensome or difficult for you, you're likely not going to have relief under that force majeure clause. Or sometimes it may say only difficult or delayed, for example. Well, that's a bit of an easier standard, a broader scope of situations. So if your situation meets the standard in the provision, what does the provision exclude? Typically, the force majeure provisions will only excuse delayed performance during the period of the delay that is caused by the force majeure event. And sometimes they'll have additional language saying, if you have the ability to find a reasonable workaround, then you have to try and continue your performance under the contract. And usually there's also a time limitation on how long work or performance can be stopped or delayed, even under a force majeure event, before the other party gets to exit out of the contract or terminate the contract or seek some other kind of relief. So the last part of the analysis is, if my performance is excused, how do I invoke force majeure? And again, you'll have to refer to the specific language in your force majeure clause that you're evaluating. And so typically, there will be some kind of description of notice requirements, and maybe even a time constraint on how soon after you're aware of a force majeure clause or force majeure event, occurring that would apply to you. You have to provide a notice within a certain number of days. And sometimes the clause will go so far as to even describe the means or the method by which you have to provide that notice, whether it's by email, whether it's by certified mail, or courier. Likely not going to see that, but it's just some examples. And so you have to make sure that you go back and you read very carefully your force majeure clause and understand what the notice requirements are, because Texas courts have interpreted these pretty strictly. If the notice requirements in the force majeure clause aren't complied with, no matter how burdensome, then you will likely not be able to obtain relief under the force majeure clause. So that finishes out our analysis of how to look at your force majeure clause, in kind of at a general 101 level, and get an idea of whether it may be applicable to you. We had touched earlier on about this unprecedented situation, with the oil price war between Saudi Arabia and Russia, situation with OPEC, the coronavirus pandemic, the collapse in demand, all of those unprecedented factors that have come together all at one time. And so, although this may not be applicable to you specifically as an oilfield services company in a direct manner, I wanted to touch on an interesting point that maybe some people have thought about, and it's that, what about if the oil market just collapsed, the price of oil has gone negative? I mean, that's never happened before. That would that provide us maybe some relief? Could we reach for that if we needed it? And the answer is not 100% certain, but there's some interesting case law out there that's touched on this in the past, and I wanted to give you a couple of examples here. From federal courts and federal circuit courts, this is where this has been held mostly, is that drastic fluctuations in oil and gas prices have been held to not constitute force majeure events unless they've been described specifically or enumerated specifically in the force majeure clause at issue, which they rarely are for understandable reasons. In one case in particular, court held that Saudi Arabia's attempted market manipulations did not constitute a force majeure under a catch-all provision. So that is an interesting piece of case law out there, and it might be indicative of how courts will rule in the future if these issues come up for litigation again, and if the situation continues or hopefully not, gets worse. So like I said, I'm going to put my email address up here. We're not going to have a Q&A session today, but I would appreciate if any of you have any comments or questions for me about any part of the presentation or even anything related to master service agreements or other types of contracts. Please feel free to shoot me an email at this address, and I would be happy to correspond with you or get with you on the phone. All right, well, y'all stay safe out there and take care, and thank you for listening in today.